welcome to the third day of the election petition hearing filed by the flag bearer of the National Democratic Congress, John Dramani Mahama, who is seeking a redress of the December 7, 2020 presidential elections. According to him, President Akufo-Addo did not garner enough votes to be declared the winner of the polls. He's therefore praying the courts declare the elections null and void, and also to make the Electoral Commission conduct a rerun between himself and Akufo-Addo. On the first day of the hearing, we had the lead counsel of the NDC applying for a motion to correct some mistakes in their petition, which was granted by the judges of the Supreme Court. And on the second day, which was yesterday, there was yet another application by lawyer Chachu Chikata, who applied that the EC admit to some errors in the declaration of the results. However, there was an opposition from both the lawyers of the Electoral Commission and Nana Akufo-Addo. Good morning and welcome in the declaration of the results. However, there was an opposition from both the lawyers of the Electoral Commission and Nana Akufo-Addo. After further deliberations by the Supreme Court judges, the application was dismissed and the case was adjourned to today, which is the 20th of January 2021. There was another interesting bit where lawyer Chachu Chikata applied for another motion that the apex courts demand the Electoral Commission to provide them with original copies of the collated presidential results of the various constituencies.
because we are the authentic and trusted voice of Ghana.
One of the best reasons for you to pay your TV license.
Very well. So GM lawyer Chachu Chikata, no, they have no better particulars. That's why he is playing delay tactics. Abronoma Nyako, Millennium City. I think that's in Kaswa in the central region. The NDC in outside court, you say you have won. NDC in court, you say you want a runoff. Right, that's from a tester from Nungwa. Hi, good morning, sir. I think the judges are trying to protect the image of that's the opinion. Right, this one says, now that the court has ruled against the petitioner's interrogatories, will there be still avenues for the counsel for the petitioner to ask those pertinent questions they seek to ask Madam Jean Mensah? I think that as time goes on,
you know, if you listen to the first respondent yesterday,
right,
the first respondent's lawyer yesterday, well, he stated that these questions that the petitioner has actually raised are in the petition itself, and they have responded to it.
Sure.
Of which Mr. Chikata said that, well, they've agreed, since he said they've responded to it, that means that there's an agreement that, I mean, these questions are that relevant. So right, I'm sure when the time gets there, they will raise this.
And also don't forget that they are seeking a review of that ruling yesterday.
Yeah.
So we wait to see what the court says, whether they are going to uphold that review and allow them to go ahead and and ask her those 12 questions. This one says, hi, I'm watching from Glife in Dansoman last stop. It will be very difficult for JM to all right. So this one says, hi, all right. So the COVID-19 is real and no respecter of persons, rich or poor. Wear your nose mask to protect yourself and others, but let Mr. Mahama and the NDC know there is no time to waste on their petition, which is, you describe it as frivolous and vexatious election petition, as described by the second respondent. I think that, I mean, it is very imperative that we wear our nose masks. I think
it's critical.
Some 3 days ago, Ghana recorded the new variant of the COVID-19 disease virus, at the airport. And so this is a point where we have to take our own destinies into our own hands. Wear your nose masks, wash your hands, sanitize them if you have a sanitizer. The integrity of our judicial system is under serious scrutiny. The judges should remember that one day they won't be there again. So their integrity and the national interest should be protected, not the precedents that will ruin our democracy. Ghana must rise again, you added there. All right, so this one says Ghana will win. Hi, I'm watching from, I think I've read that one already. This one says, good morning. Our judges should know that the destiny of Ghana is in their hands, so they should be careful. Good morning. All right, the same message there. Let me read some few more messages. We'll try and see if we can get Abduhai Mumen and the team at the Supreme Court, and then they will bring us, what's happening around that particular area. Interesting in Ghana here, election petition, John Mahama should just accept defeat like Nanado in 2013. However, I may say that the NDC are wasting their time. Abubakar Salam, you guys are too much. Keep the good work going. Thank you very much, Abubakar Salam there. This one says, interesting in Ghana here, election petition should just accept. All right. Okay, so good afternoon. I am watching live from the Upper East region. Please, I would like to know if 1 + 1 is equal to 2 is correct. Why then should 1 + 1 is equal to 3 affect the result, which is 2? Your message is not too clear there. We're still receiving loads of messages from our viewers.
The interesting thing about the various comments coming in, this is live on television, it's also live on the internet and almost every social media platform. So people actually are watching, and they are forming their own opinion and thoughts as to whatever is happening in there. So I'm not surprised about the various comments coming in from our viewers and also those listening to us too on radio.
Right, and so and let's say these are their opinions.
Yes, these are their opinions.
Not our opinions.
We just have to engage them to let them know exactly what you also make of the entire process.
Sure. Yeah. All right. So we are watching keenly. The court must do the right thing by allowing the EC to ask such important questions. Peter from Bacho now. Good morning. My name is Francis Enim. I believe in God and the NDC. Maybe you wanted to add.
All right.
Why can't the NDC wait until question time? Why can't the NDC wait until question time or cross-examination time?
Right.
And they ask the EC all these questions. This from IK Nungwa, and he says that he feels it's some way of delayed tactics from the NDC.
We'll take you over to join Abdul Hai Mumin. We'll be finding out some thoughts from him. He is at the Supreme Court, and we're going to get in touch with him shortly. But I think we're not being fair to those listening to us on radio. The number actually on radio, if you want to send us a text message or WhatsApp message for those listening to us on radio, 055-744-6429. 055-744-6429. 055-744-6429. That's for those listening to us on radio. But if you're watching television, the numbers on your screen, you can get in touch with us and send us what you think and some of your thoughts. We'll read it out. Yes,
right. So George, whilst we wait to connect with Abdul and the team at the Supreme Court, let's read some some more messages. This one says, good morning, I am Samuel Owusu Echampong, currently monitoring proceedings from Doha, Qatar, glued to my TV set. Thank you very much for watching far away from Qatar, Doha. You have to stay glued to GTV because we will bring you the reports as we gather them from the Supreme Court. Good morning. In fact, I like the lawyer for the first respondent, and that's the EC's lawyer. Yeah. Is it Justin Amenuvo? Right. So this one says, thanks for reading my message. Thank you very much for reading my message. This one says, the substantive matter for interrogatories was unanimously quashed, but it seems the NDC's joy lies in the mention of Jane Mensah instead of the EC chair. Ghana politics is sweet. Ghana is sweet. Adrianaba from Abeka Republic. Yeah. This one says, delay tactics pioneer from Buedu Emmanuel Ahafo, Mem in the Ahafo region. Hello, you guys are doing a good job. Keep it up. Ghana wins. Certainly, Ghana is going to be the winner after all is said and done. This one says, Ghana shall rise again. My name is Blah. NDC lawyers are indeed good, but they are delaying the process. They are delaying the process.
But that's just like what Dr. Kwekwajiman said. And if you read the documents or the procedures that the Supreme Court has actually given out for the hearing of this particular petition, everything is supposed to be heard within 42 days. And that's the expectation. So let's just wait and see exactly what's going to happen on the 42nd day, which will be the final day of this entire process. So let's wait and see. Unlike the 2012-2013 petition that went into 8 months, but this one, there's been a limit to it. So like the 2012-2013, the NDC even joined in that petition, but for this there's been that limit, so it's just the three of them, so nobody else can actually join in the entire process. So and the court has also given 42 days, so let's just wait and see exactly what will be happening within this 42 day.
All right. So hi, my name is Gilbert. I want to ask whether Asiedun Ketia is at the Supreme Court, because he said, okay, right, so I think today Asiedun Ketia he's actually representing
John Dramani Mahama,
the petitioner, who is John Dramani Mahama. Good morning. Good morning. The NDC is winning the case on point. I am Rina Ray GH from Kaswa. That's your opinion. It's the judges that will determine who wins this particular case. But in the end, it is Ghana that wins. The courts may grant the petitioner's request to interrogate the first respondent. I am Frank Mensah in Accra. Hi, good morning. I'm Samuel Boafo, and I want to congratulate you on the good work you are doing. I think this petition is not needed because everything shows clear that the MPP is the winner. Thank you very much for acknowledging our effort. This one says, why can't the EC be allowed to answer the questions? Courage is my name. You didn't add where you are testing from. Good morning to you guys. I think the judges are not being fair to the NDC, but God being on our side, the NDC will be victorious. That's your opinion. Tell McMail. Hey. All right, that's fine. Okay, so this one says, hi GBC, talking point. My name is Sydney Abaka from Canada. My interest in the case is to see how Jen Mensah will feel and respond to Tony Lita and Chikata in the box. That's your interest. You are very much allowed to have interest. Good morning. Michael Owusu from Asokwa. NDC should accept their defeat and the MPP should be happy for their victory. Thank you guys. Okay, so this one says that my name is Papaya, watching from South London, UK. Keep your good work. So we have a viewer, you know, way far in South London watching us. We thank you for staying glued to GTV, for that matter, GBC News or Bonu TV, any of the channels you may be watching at this particular point. Felix from Teshi. The Supreme Court has a big task ahead because it's quite obvious Mr. Chikata wants to make their work easy, but they themselves want to delay the process. And so, George, I hear we have to go back to the Supreme Court. The judges are back to deliver that ruling on the motion that the NDC filed early this morning.
All right. So let's go over to the Supreme Court. I'm sure we'll interact first with Abdul Haim and then we'll move into the chamber itself.
All right. Many thanks to you, Morris, and our colleagues in the studio, George as well. Well, the judges are yet to return to the courtroom after they went into chambers to consider the motion that was applied for by Mr. Chachu Chikata, who is the lead counsel for the petitioner, President John Dramani Mahama, former President John Dramani Mahama. And I'm sure that you are aware that as soon as proceedings began today, the counsel for the petitioner indicated that he wanted a review of the decision that was taken yesterday in respect of the application for interrogatories, which was dismissed by the court. Before then, we had also cited another motion which the petitioners intended to lay before the court today that we haven't heard of yet, but it has to do with asking the chairperson of the EC to make available collation forms, the forms that have become known as the pink sheets, that these pink sheets be made available to the petitioner throughout the process of this case. My colleague Edward Nyakon joins me to bring you an analysis of what has happened so far. So, Edward, we didn't get up to 10 minutes of sitting this morning before the jury went into chambers. For many people, the court even hadn't sat yet. What happened?
Yes, it's because of the motion or the appeal that is being made by the lead counsel of ex-President John Mahama and the President Mr. Chachu Chikata, who is asking the court to look into their own decision that they took yesterday as to the question. They said that it was not relevant to the issue at stake. So he's asking them to look into it again, and it's normal, it's within the purview of his rights to do that. So he's come to court to say, look, yes, I agree with the decision you took yesterday, but still I'm not okay with it. Let's look into the matter again. And that's the beauty of law. So that has caused the judges to go retreat and to go and look at the matter, because they need to come out with the various legal backings to buttress the argument they put forward yesterday. So they will certainly go in there to look at it, and perhaps, like I said, the second motion has been filed might have also, because Mr. Chatundi Kata need to also present his argument before that decision will be taken into, that one will also be taken into consideration. So that is what has necessitated the ladder we experience, or the break that we experience now at the moment.
One of the main arguments advanced by Mr. Chachu Chikata Counsel for the petitioner yesterday had to do with the fact that there is a precedence, and so he referred to the 2012 election petition which happened in 2013 and actually quoted judgments by Justice Gbadegbe himself, which sought to support the fact that this had happened already in the past. Some interrogatory applications had been admitted, and therefore, following that precedence, he believed that his application should also be granted. He has a point, doesn't he?
Yes, as for court legal issues, you always have a point, but it's also the judges who sit on the case and have the right to also come out with their verdict. And so if you look at what he said yesterday as part of their ruling, he cited that 2016 there's been some amendment, because 2012-2013 was a novelty that the path that we took. So it was a move by the court to say that, look here, yes, it was, but remember there's been some changes along the line. And let's not also forget that we have set ourselves a deadline of 42 days to finish this matter. So yes, you quoted some ruling, but we've moved ahead of that. We've also amended ABCD, and that's how we can grant you your request. And so we'll go back to we're saying that, look here, it cannot be granted. Let's tackle the substantive matter, and that's what he proposed, that let's look at the case management and the way forward, which Mr. Chikata requested. He want to have a look at the ruling, and then he will come back today, and just as Dr. Ayeni said yesterday, they will definitely appeal or go for a review, and they've done that today.
So what this means is that the plans were told about yesterday, just before close of day yesterday, we were told that today would be used for case management, pre-trial arrangements, and so and all of that. This means that might not happen today.
Still, I would say that the judges have the right to decide whether they're going to, because they can come back and say, look here, we've looked through your matter, your review, and this is ABCD. They will come out with their verdict. And secondly, with reference to the second motion you want to apply, he has applied, yes, whether they will allow for argument to be made today, it lies in their bosom, and so they have the right to do that. But once I believe that they have set themselves a deadline, I'm certain that they will go by, because yesterday, let's not forget that the Chief Justice said that they want to be a bit flexible. Though they have a deadline, they want to be flexible. That is how some legal pundits are also saying that perhaps they will not be able to stick to the deadline. But that's the beauty of law. Let's see how it goes, because at the end of the day, it is the judges who have the ultimate power to decide what is within the remit of the law and what is not within the remit of the law.
Many of our followers, viewers, especially on social media, have been sending in their comments. Some seek to suggest that these peripheral issues, so to speak, might end up delaying the entire process. But I also recall that even in 2013, there were several instances where the substantive matter was put aside and other peripheral matters discarded with before we continued with the substantive issues. And so you will recall that in the early stages of the election 2012 petition, there was the amicus curiae, Benoni Amekuji, who came in to as a friend of the court to make some applications. His applications were heard, but later dismissed. Of course, we also do know about the several cases of contempt that were heard during the 2012 election petition. And so this is not new at all, that certain matters other than the substantive matters have to be dealt with by the court. Edward.
Exactly, because if you're a lawyer pursuing a case, I think that you know what you want to achieve. So you have your game plan. So it's just like a coach. So you have your plan A, plan B. So Who knows? This might be part of the game plans to get exactly what they are looking out for. So like Mr. Chakata said yesterday, this is aimed at narrowing down the issues and to elicit some response from the EC. So these are some of the things they put out there to get the specifics they are looking for. Nobody knows what is in his mind. He knows what he's looking out for. And therefore, we don't have to discount on these things. It is part of the legal issues that need to be brought up. And so it's up to the opponent also to raise issues, because at the end of the day, you need to quote specific laws to buttress your argument. And that's exactly what is happening. And I always say that, look here, that is what democracy is about. I say what I want to say based on the law, and then we chart a new course. And on her side, we realize that the judges that are sitting on this case might have experience, not all of them sat on the case, but they might have a look at what transpired in 2012. So, yes, we countenance what happened in 2012, but perhaps this time around, we've got some experience under our sleeves. We're not going to consider all these peripherals, like using your word. And so we're going to go forward and deal with the substantive matter. But like the Chief Justice said yesterday, they want to be flexible and then let the case pursue. That's how you threw it to the various, the petitioner and the two respondents. They should come together and agree on when to start the case management. Right. And there wasn't a consensus.
Again, let's talk about what happened in court, albeit very briefly. We realized that on day one, former President John Dramani Mahama himself was in court. On day two, which was yesterday, he was in court himself. Today, we haven't seen him physically. We've seen Madam Jane Mensah together with her deputies in court today. Okay, so now we are getting signals that the judges are returning to the courtroom. We will continue to bring you details. Edward, you would have to move in there. Thank you very much. We'll hand you back over to the courtroom. The analysis will continue from here. We'll bring you all the details. Stay with us here on GBC platforms.
Anyway, we are sorry too. All right. By court, we have considered the petition and the answers to say by the respondents and the memoranda of issues set down by the parties. We accordingly set down the following issues for the determination of this petition. 1. Whether or not the petition discloses any reasonable course of action. 2. Whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of their valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3. Whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techiman-South constituency presidential election results. 4. Whether or not the declaration by the first respondent dated the 9th of December 2020 of the result of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1992 Constitution. 5. Whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. By virtue of the powers vested in this court under Rule 5, Sub Rule 4 of CI 99 to dispose of this petition within strict timelines. The following orders are made accordingly. 1. Mode of trial. The petitioner and the witnesses shall file witness statements with exhibits, if any, by noon of Thursday, the 21st of January 2021. 2. The witness statements shall be served on the counsel for the respondents by the close of the day of Thursday, the 21st of January 2021. 3. The respondents and their witnesses, if any, shall file their witness statements with exhibits, if any, by the close of the day on 22nd January 2021. 4. The first and second respondents shall file their submissions on the preliminary objections raised to the petition by 12 noon on Friday, the 22nd of January 2021. 4b. The registrar shall ensure service of the submissions of the preliminary objections by the close of the day on Friday, the 22nd of January 2021. C. The petitioner shall file any response to the submission of the preliminary objection by noon on Monday, the 25th of January 2021. D. The registrar shall ensure service of the petitioner's response by the close of the day on Monday, the 25th of January 2021. E. Ruling on the preliminary objection will be incorporated in the judgment of the court. Timelines. The court shall sit on Tuesday, the 26th of January 2021 for hearing of this petition.
My lords, we have just heard the orders that you have made. We thought that part of the hearing this morning was in effect to enable us to make representations on the various things, but it looks like your lordships have made certain orders, and there is some degree of unclarity, at least in our minds, as regards what is referred to as a preliminary objection. Because, my lords, there are, in the two answers, there are a number of different things that are referred to. I'm actually not clear.
Of the primary objection. The issue to be determined as preliminary objection. That has been set out as read by the President of the court.
Well, perhaps we could hear it again, because it was not...
Is whether or not the petition discloses any reasonable course of action. That's it. Please, we will instruct the registrar to type the orders by the close of the day, and they will be served on you. Because it's case management, you have to be fully informed of the orders.
My Lord, with respect, it is case management, and I believe we have an input that we can also make as parties, because we had, for instance, witness statements. Is it by tomorrow? I mean, my Lord, with the greatest respect, I mean, we are human. I mean, maybe they're superhumans, you know, but we have filed this morning. As of this morning, we have filed an application for review of a ruling that you delivered yesterday. There are consequences to that. We also have outstanding requests to admit facts, which are due within 3 days from when they were served on the other party. There are a number of outstanding issues which have not been discussed.
Mr. Jigata, there's no outstanding issue. The application for review of our ruling yesterday does not operate as a stay of execution.
Well, I did not, with respect,
we are operating on strict timelines under CI 99.
And to have the notice to admit.
Yes, but my lord, it can affect the issues. In fact, your lordships will recall that yesterday, when we were discussing the filing of the issues, we raised the point that the matter of the interrogatories and the notice to admit facts could affect the issues that we filed. There are some issues that we may not actually require.
Mr. Chikata, if you get there, can't you apply for these issues to be taken as an additional issues?
Yes, but in the meantime, we'd have filed witness statements, yes, which are limited to.
You are call 5 witnesses. I believe you should know what they are coming to say. As at the time you were indicating that you were going to call 5 witnesses.
Yes, so we are going to have 1 day within which to supply witness statements in respect of 5 witnesses. Is that? I think that I think that with respect is not fair to us, because with the greatest respect, we have indicated that we have 5 witnesses. We may end up not calling all 5 witnesses, but in any case, we have now, today, until tomorrow, in order to prepare witness statements.
Mr. Chikata, this should have been prepared already. No. Well, these statements should have been prepared already.
Well, that is not correct. Maybe your lordships,
Mr. Chikata, excuse me. Mr. Yene, please, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair. You see, the other time we heard you clear when an objection was taken, when the representations were announced. I even asked Mr. Chikata whether they were limiting themselves to the only 2 counsel. Mr. Chikata, I think you remember the very day, and you said you were with only Mr. Luther, and you were recorded as such. But Mr. Yine, please, out of respect for you, please don't do that again.
Mr. Chikata, if you recall, we've gone through the regimes of CI 87, we've gone through the regimes of even witness statements in criminal matters, and so where we've arrived at now in administration of justice and case management is preparing everything up front, and I'm sure you are quite aware of that.
I'm aware also of the fact that it is a matter which parties may make representations about. That is a matter of whether it is conducted through witness statements or through oral testimony. I mean, that is also a matter to be considered on the basis of representations made. But, I mean, your lordships have made the orders already, and we will be served with them, and I believe we will advise ourselves. But I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Chikata, you know about CI 99 and its schedule. That's the 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
The petition is hereby adjourned to Tuesday, the 26th of January 2021 for hearing.
We are grateful to the court.
Please, resume your seat, please. Lords, we are most grateful.
Rise.
All right. Let's go.
Counsel, your reaction to the ruling of the court.
Out.
Came out of court. You all know what was scheduled for today was to be the pre-trial hearing. But before that, the petitioner's team, lawyers, had indicated that they had filed an application for a review of the court's ruling yesterday on the dismissal of the interrogatories. Well, the court took cognizance of that and retired into chambers to consider the issues that we had been ordered to all file. So at the end of the day, the court came back and read the memoranda of issues. 5 issues have been set down for the trial and determination of this petition. I'm confident that in the short course of time, you'll be apprised with the issues that have been set down. The court has also given an elaborate timetable for the hearing of the petition in strict conformity with the CI 99. So we are all supposed to be back on the 26th of January, that is Tuesday, this coming Tuesday, for the hearing of the petition to commence in earnest. It is instructive to let you all know that the 3 issues that we set down as our memorandum of issues have been incorporated largely in the issues set down by the court. Now, the court has also set down for legal arguments, a preliminary legal argument, whether or not the petition discloses any reasonable course of action. Indeed, in second respondent's answer, that matter was raised by the second respondent's legal team as a matter which should be considered by the Supreme Court, and that has been set down for preliminary legal argument. When the decision and the rulings of the court was read, lead counsel for the petitioner raised the matter as to the filing of the application for review. But that was sharply responded to by Professor Ashi Kote, Justice of the Supreme Court. We all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. Well, the return date for that application is tomorrow, the 15th. It's tomorrow. We will be in court tomorrow for that application to be heard. So yes, that is what transpired in court this morning. I don't understand what that submission is supposed to mean. They always are the first to make those submissions, but that submission has no place in law. As petitioners, they should have known that CI 99 governs these proceedings. And CI 99 has been in place since 2016. When did they realize about expedition, delay, and justice? Of course, expedition is justice. You don't come to court with a set of rules and you want to circumvent and obviate the rules by your own careless abandon. How do you come to court with a petition and you don't know that you have to file a witness statement? You don't know that you have to settle a memorandum of issues? I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you. They were advocating for a live broadcast of the proceedings. Not averse to it. Everybody is seeing what is happening in the Supreme Court. Every single day, lead counsel for the petitioner has one complaint on the other. You cannot blame the failure of a bad farm on your tools of implementation. Your farm is your farm, and it depends on how you cultivate it. So we should also not pander to this repeated rhetoric of sacrificing justice for expedition. It is the main reason that the election petition of 2013 delayed for 8 grueling months in court. Are they anticipating the same thing? I believe not.
As an interested party, are you not concerned that in the future, when this case has traveled and the issues are brought back, that it could take all of us back to the very beginning of matters?
The Supreme Court is the determinant of its own rules. There are set rules governing the election petition. The application for review will be heard tomorrow. Whether they are successful or not is not left to me. I'm a trained lawyer, I'm not a clairvoyant. So what happens today will determine the course of the proceedings. Final question? Any more? Thank you. Thank you.
Please. It's okay. It's okay.
Yeah, according.
Yes, what is the evidence ask?
No, I think we just
okay.
And greet them and then.
All right. Good morning.
All right, Counsel, thank you very much. Give us your reaction to the court's ruling today.
Well, we are quite shocked because we are here for pre-trial, for case management, and for those who've been in court, we know what case management is. Case management is a discussion between the parties and the court as to how the trial is going to proceed. Today, that's not what happened. We were told what is going to happen. There was no discussion as to what our views were on how the case should proceed. So we are quite shocked.
We understand tomorrow is the day you will come and argue your case out.
No, that's not the case. What the court said was that we file our witness statements by tomorrow, by 12 tomorrow. Now, that means we have just one day to prepare the witness statements. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review of their order yesterday relating to their refusal to grant us leave to serve the interrogatories. That has actually been fixed for the 28th. Now, all those things will have an impact on the kind of witness statement we will prepare and file. So if those issues have not been dealt with, those applications have not been dealt with, how do we file witness statements by close of business on the 21st? For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years. And we know what the rules are. We know what the rules are.
Counsel, for the second respondents think that they're not well prepared for this trial. You seem to raise objection to everything the court raises.
And every objection that we've raised is grounded in law and is justified. I'm sure you are all witness to the arguments made by lead counsel yesterday. Did those arguments sound like they were just a ploy to delay the case? They were grounded in law. The fact that the petitioner has interrogatories to serve on the respondents. Now, interrogatories, as he stated, are to aid the trial of the case. And indeed, if a petitioner who has, or an applicant who has good grounds for serving interrogatories is denied the opportunity, for us that's a denial of justice.
In terms of the timelines that have been imposed, I mean, as it stands now, that is the timelines you all have to work with. I mean, is it something that you will be able to meet? And in terms of your case, you are the ones who have brought the case to court. And what does it mean for putting together a solid case to put across your points?
Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court, we wouldn't have filed the petition in the first place. all we are saying is that processes we have served, processes we have filed, processes that need to be dealt with have not been dealt with. How do we start a trial? That is all we are saying. So if you ask us to come to court on the 25th to commence a trial, how are we going to start a trial when our notice to admit facts has not been dealt with? Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Given your experience at the bar and with the experience of the 2013 petition,
yes,
and the position you are now in, do you think that the 42-day timeline is realistic enough for you to conduct an election petition?
Please note that under the rules, the schedule, there's 5 days for pre-trial. Today is the second day.
So what's the rush for?
So what is the rush? Today is the second day for pre-trial.
5 issues have been set down for trial. What do you make?
Well, we are yet to, I mean,
Serve the order.
we are yet to be set the order. We are now going to look at, because it was just read to us, we need to now sit down and look at it. Did it, because we have also filed our memorandum of issues. Does it take care of all the issues we put before the court? Because that would have been the essence of case management. The parties going back and forth on the various issues they filed, and the court bringing it together so that we are all agreed on the issues. That didn't happen. So we are now going to look at it to see whether it addresses the issues that we have raised in our memorandum.
Counsel, your colleague, Dr. Ayemi, was remanded by the court for certain gestures. What response to that?
Doc, you do that.
Doc apologized, and I think that should end it. He's a gentleman. I don't think he'll ever be deliberately rude to the court. The court took offense. He apologized, and that ends the matter. So thank you very much.
Can we get TV?
Yes. Baba Jamal. Yes.
Yeah. This one, you are dealing with your friend.
Yes.
Your friend.
The chief can come up.
Mr. Ene, once my boss I have a specific question. Which one?
What has accounted for the inability of the plaintiff?
No, it is not the inability of the petitioner to bring witnesses. All right, we had indicated, in our petition that we will be calling most likely 5 witnesses.
Yeah.
Okay. Now we thought that at case management, at the time of case management, which is 5 days of, okay, a 5-day timeline granted by the court itself in the new rules. Okay, we thought that we should be in a position, okay, to plan together with the other parties on how many witnesses we are going to call. So it was not the case that we are not prepared with our witnesses. It is just the case that we are met with a situation where we are being given 1 day to prepare our witnesses and then make sure that we file the witness statements, by noon of tomorrow. So it is not about us, it is about the tight that are being given by. And I think that the court is being very unfortunate. When you have indicated that pursuant to CI 99, there are 5 days for case management, and all of a sudden the case management is reduced to 1 day by the court arbitrarily without any consultation with the parties, all right, then that is our lead counsel, Tachuchikata, made it very clear. They are seeking to sacrifice justice on the altar of a so-called speedy trial. Okay, and that is not fair. The fact that we spent 8 months, right, dealing with the first presidential petition does not mean that now everything we do
must be geared towards, attaining a speedy trial at the expense of fairness. Okay, and I think that is a very worrying development.
But your opponents also say that justice delayed is justice denied. Speed and justice probably go together in this instance, and the assertion is that you are delaying.
No, that means that you cannot sacrifice one for the other. Justice delayed is justice denied. That is true. However, the court itself has indicated that we have 42 days to complete this trial. It means that in the wisdom of the drafters of the rules, that is the Rules of Court Committee, 42 days are sufficient for purposes of conducting a trial in relation to a presidential election petition. Okay? You cannot now begin to truncate and deny the parties the right to be able to, for instance, file preliminary, applications that are mandated and allowed by law just because you want a speedy trial. Okay, and to be honest with you, I was shocked at what was happening, and you all realize that the Chief Justice singled me out, that my body language was inappropriate. But that is because I was very shocked, because after 25 years of law practice, I have never seen this happen, that a court will arbitrarily announce the timelines for the parties without consultation. I had occasion to ask Mr. Akoto Ampao why he did not object to the tight deadlines. Okay? And sitting down there, it reminded me of an inscription that was on the desk of my secondary school rector in Notre Dame Secondary School. It said, "Don't confuse me with the facts. My mind is made up." Thank you very much, ladies and gentlemen.
Thank you very much. Honorable Kojo Ponkroma, who is the President's representative at the Information Ministry, will speak to us now. Yes, so how do you react to everything that has happened in court today, very briefly, sir?
I think all of us need to go back to the basics. Ordinarily, when you file your petition and the respondents file their answer, the next logical step is case management, which starts with a setting out of the issues and then a timetable which includes when witness statements are filed. On the first day when we came, our colleagues from the other side started off with an interlocutory application asking for leave to go and amend. And therefore, they started delaying the 42-day clock. That was granted. We had the opportunity to come back earlier this week, and the afternoon before we appeared in court, they filed another interlocutory application, which, as you all saw, took us, almost 2 hours or so, and the court dismissed and said, let's go back to case management, which is what we should be doing now. Every lawyer knows that by now, when you are coming to court for case management, first, your memorandum of issues, you've drafted it. Second, your witness statement, you have a draft of it. So these matters become procedural. Because our colleagues are seeking to delay the process and get a media spectacle ongoing for some months, all they are doing is theatrics in the chamber, seeking to delay the time. So today, even after the court has ruled, or just before the court rules, they bring another application for review. Every lawyer knows that the law is that an application for review or an appeal does not operate as a stay of proceedings. Every lawyer knows this. So you cannot claim or pretend before the cameras that by mere virtue of the fact that you have filed an application for review, there ought to be a stay of proceedings. Because it has actually been, I think, slated for hearing tomorrow. The return date, I think, is tomorrow on it. It will be heard.
Counsel for the petitioners feel that they in fact took an exception to the argument that they are delaying the trial.
They are allowed to take an exception.
What they are doing is due process.
They are allowed to take an exception. But I want to come to another issue. When the court determined in the end that witness statements should be filed on X or Y date, you can check from any other lawyer. Mr. Mahama filed his petition on the 30th of December. True or false? Okay. Nobody chose witnesses for him. He listed 5 people that he had as witnesses. That presupposes that
He knows who they are. He knows what they are going to say as witnesses on his behalf. Today, when the court says that by this date, bring me the witness statement, now they say it's too short and that they are being rushed into putting together witness statements. We didn't choose their witnesses for them. From 30th of December till now is what, 20 or 21 days? And Mr. Mahama's lawyers are saying to us that they have not drafted witness statements. They don't have a draft of it. From 30th of December, when they filed their petition and chose their own 5 witnesses, they didn't know what the witnesses were going to say. They haven't drafted it. Respondents have listed what they want to do, and we have a fair idea what it takes to contend this case. Now, if they claim that they need to go back to the interrogatories before they can agree to the issues as have been set out and prepare their witness statements, what it means is that their application for interrogatories were a fishing expedition. That what they were doing was to use it to explore what issues they can come to court with. They have been very clear to the Ghanaian public that Mr. Mahama won this election. Mr. Mahama himself at his press conference said he won the presidential election. That means what? He got 50% plus 1. You have an opportunity in court to prove that. Now Mr. Mahama abandons that one and moves on to this new thing of nobody got 50%. And when we say bring your witness statements, he says it's too early to bring his witness statements. Okay. That's ridiculous. And we are of the view that these are just efforts to delay what CI 99 sets out clearly, that there must be justice, but it must be done expeditiously. Nobody is short-circuiting the process.
You seek to emphasize the fact that your opponents are seeking to delay the process. Because what do they stand to benefit if they delay the process?
They are looking for a media spectacle so that Mr. Mahama can continue to remain very relevant in the NDC and in the public space and run again in 2024. That's all they are looking for.
He stated that in terms of case management, it should be done among the parties involved in the case. But this time, the court has set its own rule, and they find it very ridiculous.
That is not true. You were all in court yesterday. In fact, even yesterday, when the court said that they should make their input into the first part of case management, which was the memorandum of issues, you saw them object. The court could have set, in fact, traditionally, the court will set out the issues. Now with the reviews, CI 87, etc., with the reviews, the court will invite counsel that give us your memorandum of issues and let us come up with a timetable. Let's listen to your issues and simplify. We went with 3 issues. In the end, the court came up with about 5 issues. 2 other issues that we were not contemplating. The court has added it as the list of issues. We are not complaining. We think we can respond to
right. Honorable,
this claim. You were all in court yesterday when they were even asked to file their memorandum of issues. You noticed that this morning they were late in the chamber. They were late in the chamber because they claimed they were now filing their memorandum of issues after they submitted their petition on the 30th of December. Now they are being asked to bring their witness statements. They are suggesting that it's too early. 21 days after they told the whole world that these are our witnesses, they have evidence to support our petition. And that is why we are saying that they are continuously trying to put impediments in the way because they want a media spectacle.
Honorable, for the millions of Ghanaians, lay persons watching us right now, who perhaps also sympathize with your side and who do not understand what the court ruling was today, how would you summarize it to them?
The court has ruled today that let us get on with the issues. Let the petitioner prove that nobody got 50% plus 1. Let the petitioner prove that the results were in contravention of Article 63 of the Constitution, as he's been claiming. I would have even preferred that they had come back to say that Mr. Mahama won this election. But you notice that they have abandoned that since they came to court. And so the court did not pick that as an issue. But what the court has said is that all the gymnastics around, let's get to the substantive issue, and has asked us to come and deal with the issues that it has set. In Chi,
all right, thank you very much. And that was the Minister for Information, Mr. Kojo Ponkroma, speaking to us earlier. We also spoke with the Minister, the former Deputy Minister,
and Attorney General, Dr. Dominic Ayine, and both of them telling us their points of view as to what happened in court today. The Minister for, the President's representative at the Ministry of Information making a claim, a very strong claim, and I'll be joined by my colleague Edward Nyakon, Barbara, who also joined me at the moment. So as we begin to wrap up for the day's events, Barbara, let me start with you. The Minister says, well, now the court has given, paved the way for the proceedings to hear the substantive matter to begin. What was your understanding of whatever happened in court today?
Well, I think I'm going to agree with the minister when he said that. I mean, the court says that now let's stop with all the gymnastics around. Let's get into the real matter. Let the petitioner come and prove his case. Come and prove to the court if he indeed has any case to be argued about, or to even for the court to listen to. So yes, I think it's about time we started the trial itself, and the court has said it, that next week, Tuesday, 26, we sit on the petition itself.
Edward, but again, we notice, I mean, proceedings came to a halt for the jury to take a break and go into chambers to take a decision. But that was because the lawyers for the petitioner had asked for a review of the decision that was taken yesterday, dismissing their interrogatory application. Again, when the court came back, one of the issues they spoke to was the fact that, well, the fact that the petitioner has asked for a review does not place a stay on the proceedings, and therefore the proceedings will continue. But then again, the question is, at what point will a decision be taken on the review? And if a decision is taken and it goes to the advantage of the petitioners, will that not then put everything in reverse gear, since we would have moved forward at a point?
Well, if you listen to the arguments put forward by both sides of the coin, that is the second respondent legal team, as well as the petitioner's legal team, you realize that if you look at it from the view of the second respondent, they are claiming that it does not affect the substantive matter, because the judges are masters of their rule. And so if they are set tomorrow for that, and they are expected to also to file their memorandum of issues and witness statement today by close of day, it doesn't change the matter at stake. And so they are in a position to deal with it. And but if you look at it from the angle of the petitioners, they are also saying that, look, it will affect the statement of the memorandum of issues and witness statement they will put out there. So these are all legal issues, but let's not also forget that the court indicated that they have looked at, they should all remember, be mindful of CR 99, which sets the rules that, look here, we're not going to go the way we went 2018. We have to set a rule, and there has been a review, an amendment to all those previous issues. So pre-trial matters should not be able to stay or prevent this substantive matter from coming on board. So this is how the issues are playing out.
I'll come back to you, Edward, but the issue, and let's toss this around amongst us. You know, the lead counsel for the petitioner says it appears as though the court is sacrificing justice for expedition, justice for speed. Does he have a point? I mean, from the arguments he made and so on. You have been reporting from court for a long time. Is there a way that justice goes with speed at the same time?
Yes, definitely. I mean, it is not every time that you come to court and the processes are delayed here and then and all that. I believe the Supreme Court and the justices of the Supreme Court are well aware of the laws, and they know exactly what they are doing by asking that we fast track the process. At the end of the day, justice will be done to whoever deserves justice. And so, well, the petitioner, they have their own issue, but I believe that the law is working, and that is what we should allow, or we should allow to go through the whole
All right, Edward, your take on that as well?
Yes, it goes back to the CR99 that that judges refer to, that Mr. Chikata should refer to the CR99, which he agreed that he's aware of that, the schedule that indicate that it must be dealt with within 42 days. So in the purview of the judges, this is the way to go. And as always said, they are the masters of their own game because they set the rule and they can do whatever they want to do with the law.
We have to go now, but very finally, so court sets again exactly when? Because we heard announcements about filings being done on Thursday and on Friday. Yet we
substantive matter, court sits on Tuesday, but on the review, it will be done tomorrow.
So tomorrow we are coming back to court?
Not for the substantive matter, but for the review. But for the filing of the witness statements and other processes, it should be done within by the close of this week. That is what the court has ordered.
All right, thank you very much, Barbara Kuma, and thank you also, Edward Nyakon, my two colleagues who have been here with me in court. Earlier, we also spoke to our other colleague, Beatrice. Yvonne, our other colleague from the radio, has also been here. We will continue to bring you all the details about Election Petition 2020 and whatever you need to know, including what will happen tomorrow. This is where to get all the authentic information. My name is Abdulhai Mumin. We are grateful that you have been doing this with us. We'll go back to our studio where our colleagues are standing by to bring you further analysis of all that has happened in court today.
That they were seeking. The court returns to spell out the modalities of the case, how the case is going to be handled, and they have given 5 orders. One of them is whether the petition discloses, if any, reasonable course of action. We have our lawyer on via Zoom. We'll be speaking to him to understand some of these orders. Whether or not no candidate obtained more than 50% of the votes, valid votes cast. Whether or not the second respondent, who is Nana Adodankwa Akufo-Addo, did not violate Article 63.3, which says that a winning candidate must have 50% plus 1 of the valid votes cast. Whether or not the declaration violated Article 63.3 of the Constitution. So those are some of the orders and how the whole process is going to be handled in court. We still have on the line lawyer Dr. Kweku Ajiman Budu. He is a law lecturer.